We've now emptied half of the room onto this platform. I was intimidated by the notion that we were going to have a session on hard questions, and I thought if we're going to have hard questions, we better put all of the people who can answer hard questions on the stage. Do they look cosy and comfortable? Okay. So we're going to finish up at 4:30, but as I said at the beginning of the day, and I know in the breakout sessions we had opportunities for questions, but we thought it would be really useful, insofar as we're able to just be able to try to bring everybody back into this room and throw this open then for very broad discussion or conversation. So it really is over to you now to try to, so we can come together and share each other's insights or pick each other's brains or do whatever we can possibly do at the end of what I think has been, certainly from our perspective, a really rewarding and stimulating day. We hope you've enjoyed it too. So we'll throw it open straight away rather than have me waffle on for 20 minutes about what I'm going to do. Questions from the floor, anything. So we'll get microphones over there. Lady here first, and I might take a few, but we'll see where we get.
Hi, I'm Mimi Meyer from the Philippines. I'm studying criminal and forensic psychology in independent colleges. My question to the panel is, well, actually, I've got two.
Go ahead.
But first is, I was wondering what you think is the most important, what do you think the most important human right is? And second, the last but not the least, most of the time things are viable only in theoretical terms. Practically, they are generally not implemented. But nonetheless, people voice their opinion, people voice their needs to the government. Only those who have power are able to voice their opinion. Please elaborate.
Okay. We'll take one more there. There's somebody else there just behind you.
I was just going to say, is there hope? Where we are at the moment, can you think of those sparkling achievements and things that we've achieved at this point in time that give you confidence about the future?
Okay. Anybody else? Okay, I'm going to go back to the panel just to keep things moving, but if you put up your hand whilst they're answering, I'll also then be able to get to you pretty quickly. Mary, there was a question there about power, so I'm going to come, Mary Murphy from, I might come to you first if that's okay, because it seems to me that speaks directly to what you're talking about.
Yeah, okay. I've made it a rule to be optimistic for the last year or two, so only those who have power can change things, and examples of power changing things. I mean, I do think that there are any amount of examples of where things changed fundamentally in the world. I mean, gay rights movement in the States, the civil rights movement, apartheid finishing in South Africa, the Berlin Wall. Yeah, I mean, look right back throughout history. Most of the fundamental structural changes that we see only happened because of a mobilisation of people from below, where often they worked in solidarity with each other. And if you look over the longer picture, you know, shorter than 4 or 5 year spans, normally you do see that people working together actually do change the world at some level. And so I'm desperately clinging on to that fact, because it is a fact, and sometimes it's very hard to see in the midst of crisis where we are going with this, but I do resolutely believe that by keeping those principles of working together, keeping normative things like human rights on the agenda, and engaging with each other across those things, and challenging each other where we need to keep something moving, that I would still be hopeful. Yeah.
Does anybody want to even try and answer the question, what's the most important human right? Iain.
I'll get this out of the way so that the technical questions can be answered by other people. I mean, I suppose you might naturally think, well, you know, sort of right to life, because it's sort of, you know, all the other rights derive from it, and you know, in some countries, you know, the courts have used the right to life to indirectly protect economic and social rights, and we all think of leading a dignified life. But for me, I suppose, right to participation, or certainly right to a remedy, I think are critical, and it's really what I was saying sort of earlier on this morning. I mean, this theme of accountability that we've talked about through today, and I think, you know, it's all very well to say to people, you know, even if they're not, you know, A, make them aware that they've got any rights, but then, okay, what can I do about it? And the fact that, you know, if something goes wrong with your rights, can I get some form of remedy? That might not mean going to court or compensation, it might mean just something, the same thing not happening again. And unfortunately we keep on seeing that. We don't seem to learn from the mistakes of the past, and we could look at the current economic crisis as to why we have it, you know, why do we continue to repeat that? So that's what I would say.
Maybe if I can continue with that, we don't really have to choose a most important right, but I would suggest the right to equality and non-discrimination is especially important, because many human rights violations go down to people either explicitly or in practice receiving less favourable benefits than others. And so things like denial of the right to vote to prisoners, for instance, isn't just about the right to participation. As mentioned, it's also a non-discrimination and equality issue. So I think that's a particularly important cross-cutting obligation.
Anybody else on the panel want to speak to that one? Okay. Questions from the floor? At the end of a day like this, there has to be some. Lady just here, and then we have another one here. Thank you.
Thanks very much, Katie Boyle from the University of Limerick. It was really helpful to hear all the discussions today, and thank you very much to all those in the panel. We heard a lot about the opportunity to pursue judicial remedies. We also heard a lot about pursuing non-judicial mechanisms in order to secure economic, social and cultural rights. And my question is, what do you think is the best approach to persuade or to engage with sectors from society, particularly those who are in the position of making important decisions and who are not convinced by the enforceability or justiciability of economic, social and cultural rights? How do you best engage with that particular argument? I think it's quite easy, or not easy, but it's very helpful for those who are convinced by it to discuss it, but how do we engage with the sectors of society who are not particularly persuaded?
I'm going to open that one up straight away and then come to the next question, because it really speaks to the heart of what we... Who'd like to take it? Grania, and then Aoife.
Thank you. Grania Healy from Marge Equality. I think, in a word, mobilisation. So whatever the particular area, in my own case, looking at LGBT rights and specifically the right of same-sex couples to civil marriage rights, moving an issue that was really not on the agenda at all, and over a period of a decade, moving from something that had a less than 25% interest from the general public to a 74% interest and support of it. So there's no doubt that those who are in a position that within whose gift it is, in our case the legislators, the mobilisation is huge, and then the communication of that mobilisation and the sense that there is a demand. I mean, there's no doubt that we've had a number of different strategies, including a legal strategy which took Catherine's opponent, Anne-Louise Gilligan, to the High Court. And one of the things that the High Court judge said, Justice Dunn, in her decision there, actually said that she had no sense that this was an issue, that there was any kind of a demand for in Ireland. So they're the kinds of nuggets that are really useful when you are a campaigning organisation, where you see that this is not some kind of objective justice that's been dispensed. It's a matter of, listen lads, there's nobody out there telling me that this is an issue, so we really need to tell them, whether they're in the judiciary or whether they're in the Dáil, that these are issues, and the strongest way of doing it is to mobilise the people themselves to tell them and find ways of facilitating that to happen.
Aoife?
Yeah, I suppose taking a slightly different perspective, when it talks, when you're dealing with people who don't necessarily engage with or aren't sympathetic to economic and social rights claims, I'd say there's two major issues that you come across. The first one are general misunderstandings about economic and social rights. That's not just amongst people who are anti-economic and social rights. I mean, I can remember one example where being involved in the Bill of Rights process in Northern Ireland, where someone said, well, there's a right to have a house in the same on the same, in the same village as your parents, and you're like, no, actually there isn't. But do you see what I mean? And that was someone who was very positive about the right to adequate housing as they understood it. But it meant that you could see how government policy makers who heard that were just like, is that what the right to adequate housing means? Oh my goodness, right? So what I would say is that education plays an important role. The other thing is, though, that all of us know that education only gets you so far. There are some people who are really, economic and social rights, if fully implemented in Ireland or elsewhere, is going to really challenge the status quo distributions. That means that people are not necessarily going to predispose towards them. The haves are not going to be particularly keen on passing power over to the have-nots, as Mary was saying. And what I would say is that's important, one of the things that with economic and social rights you can do is certainly is to make very good arguments with regards to how people, first of all, that they have a stake in them. You know, we're all going to get old. We mightn't all be at risk of poverty, but we're all going to probably need care in our older years, right? Children all have certain needs, some have more pronounced than others. So there is part of it is about presenting these as not something that happened to the small group called the poor, you know, that we can kind of shuffle off into a particular corner and demonize and stigmatize, but actually to make it clear that these are rights that, you know, in different ways apply to a whole range of people. One example with policymakers as well is to recognize that we have a tendency to assume often that different departments in government or the state as a whole have the same agendas. And one thing that's been very interesting is in the context of, say, austerity measures, it's become very clear that, for instance, local authorities' agendas may be very, very different to what you're seeing at a national level. Health's may be very different from education or from the Treasury, etc. And one of the things is that if you can convince different departments or different state actors that economic and social rights can serve as tools for them, for instance, in protecting their programs, protecting their budgets, that's a way forward. And there's certainly currency in that argument. So sorry, so those are kind of three main ideas.
Okay, another question from the lady here, and then we'll come over here.
I kind of just wanted to pick up on what's happened with Mary Murphy in the last session about the power dynamics and the power inequalities in society, and how the people who most need access to services are those least likely to be able to access those services the way that they need. And it's kind of, my question kind of centers around what we can actually do to help people with that, kind of from a kind of pro bono advocacy services that we can offer, drop-in clinics, and kind of the best ways to organise that. I mean, from my own background, doing law in UCC, I know that they have a clinical program where they offer the services of law students to research these kind of questions for law firms in the area that may not have the time to dedicate the resources to that. I know that the PILA network is trying to set up kind of a forum for experts to kind of give an hour or two to people to answer these kind of questions. But I was just wondering, in your years of operating in this area, have you come across any kind of best practice models as the best way to kind of facilitate that, to allow a professional working in the area to give an hour or two a week to answer these questions, to meet with people and say, in their particular areas of expertise? I know, for instance, in immigration law, that because it's such a discretionary system, that people aren't aware of exactly how it operates, exactly the appeals mechanisms, how to navigate all of the information. I know of one example where when you read the statutory instruments in relation to, I can't remember, but a particular issue, it says that there's an appeals ground or an exemption ground, but when you read the information on the department website, they don't highlight it, even though they have it as a policy. That's a level of knowledge that requires a high level of expertise to actually get to. So how do you facilitate people to offer that service for free in a drop-in clinic in a way that's easy for them, that they can manage in the evenings or the afternoons if they want to?
There's another question just over here. Lady at the end table there. And they're coming in fast and thick now. That always happens.
Hello.
With a queue.
Hello, my name is Anne Campbell. I just wanted to add my thanks to everybody for the really, really fascinating presentations and the excellent information that's come out today. There have been a lot of discussions about the optional protocol to the ESCR. And I think my question is possibly going to be aimed at Michael. If and when the OP comes into force, and I'm not sure how many ratifications it has at the moment, but is there a sense among legal practitioners in Ireland that the OP is a viable strategic litigation avenue for pursuing the justiciability of ESCRs in Ireland? I believe that there's a requirement to exhaust domestic remedies, and if so, then cases that are currently in the courts could, in theory, be brought before the SESCR committee once it actually comes into force, which it should do, I think, relatively soon. And in addition, how does that compare to bringing cases before the European courts? Obviously, the European courts have much stronger accountability mechanisms, I suppose, for the state. And therefore, what is the added value, in your view, of the OP procedure? And then I would just open the question up to everybody else and say, what is the feeling among NGOs on that point? Thank you.
Michael, I think you're well placed to actually deal with both of those questions, because the first deals directly with access to justice, I suppose, or how we can make that, which is FLAC's mission. And then the second question was directly to you.
Well, if I can say about the first question, giving advice and information to people, well, that's what FLAC does. And FLAC runs about 70 information centres where lawyers give of their own time to help people, give them information about their legal problems. That's a very valuable service. It shouldn't have to be provided by us, it should be provided by the state. But historically it had to be provided when there was no legal aid at all. It had to be provided by FLAC, and it still does. But there is, in addition to that, things like the Citizens Information Centres, which do provide a very valuable function as well. But that simply gives people information. It doesn't take cases for them, nor does it mobilise people to change the law. And this is something Mary was talking about and Corona was talking about, that in order to change the law, you have to have a number of things. You may have to, in a lot of cases, you will have to go to court to do it. But what I was saying earlier today was that you may win court cases and it doesn't necessarily lead to change, because the government may simply ignore or implement those changes in such a way as to make no real difference. And to secure fairly fundamental change, you really have to mobilise a fairly substantial section of the population to demonstrate to government that they have to change. And you're talking about inertia here, or you're talking about vested interests. And vested interests rarely give up their vested interests unless there is some fairly strong pressure on them. So, you know, I would say, of course, what we do we think is very valuable. It's very good if law students want to get involved in this sort of thing, but it has to be carried on in two ways. One, it has to be carried on in terms of actually providing pro bono representation to people as well. And even that has to be married with working with communities and mobilising people to secure change, because implementation is as big an issue as winning cases. On the other question of ESCR, well, the difficulty is going to be that decisions by the ESCR committee are not going to be enforceable here, as are the decisions by various other UN committees. I've been involved in taking a case to the UN Human Rights Committee where we won the case, but we couldn't enforce it. And in some informal discussions about this, you have, and it was being said in the last session, that, you know, there's a huge number of unimplemented decisions. So I think it's very important, and also there's no guarantee that our government is going to ratify this. They've signed it, but they've signed a lot of other things, including the Disabilities Convention, and they haven't ratified it. You know, that they signed that a long time ago. They were one of the leading countries advocating the Convention of the Rights of People with Disabilities, and then they don't sign it. It's come into operation with other people signing, or ratifying it, sorry. But our government hasn't ratified it, and it's still dragging its feet on it. So, now, is that to say that this is no use? It's not at all. But you have to have a strategic approach to these things. Decisions of our domestic courts can be implemented. Decisions of the European Court of Human Rights have a little more strength behind them, but look at the C case and the fact that nothing's been done about that, and if it is, it will probably be done by the very tragic death of the young woman in Galway rather than the mechanism from Strasbourg. But it doesn't mean these things are not important. They are very important, they're very useful, but a lot of what they do is raising awareness. If you take a case to one of the international bodies, and if you win it, you raise, there's reporting of it, you raise awareness, and you get from that international body a confirmation of the legitimacy of what you are doing, that this isn't some way out wacky thing, that this is something that is within international human rights law. And that's very important in terms of mobilizing more people in favor of it and putting more pressure on the government to change. So providing you see these things in their context and don't think that they will resolve every question or that they provide a panacea, then they are valuable and useful to use in conjunction with other methods, and in conjunction particularly with trying to mobilise public opinion about the issue. So, I don't know whether that's
Thank you,
useful.
Michael. Anybody else want to comment on the optional protocol specifically? Ignacio, were you interested there as well? I think. So we'll take, and then we'll take Ignacio afterwards. So go ahead.
Just a comment, I don't know if we want to be thinking about the European Court as a role model for the UN treaty monitoring bodies, simply because the European Court, with its system of individual petition, which undoubtedly is one of the great achievements of the Council of Europe since the Second World War, also has problems of its own with the backlog of nearly 150,000 cases in Strasbourg. So we should be trying to think, I suppose, of different mechanisms that won't bring with it those sort of attendant negative consequences.
And Ignacio?
Yeah, on the optional protocol, I mean, as an NGO that's extremely excited about the prospect of the optional protocol actually coming into being in the next few months, I mean, I would say that in a way we have to remember that its value, one of its strongest values is its symbolic value. As Iain was saying in the workshop, you know, it's the symbolic nail in the coffin of the long-standing argument that these rights are somehow second-class rights and they're not justiciable. I mean, we know that, those of us gathered here, that they are justiciable, and that's been proven at the national and international level. But I think finally having a complaints mechanism that is on a par with the one that has existed for decades with regard to civil and political rights has enormous symbolic value. And I think it has a deterrent function too. I mean, you know, the number of cases that will be brought will be typically the iceberg cases, but its mere existence should, and this is what international mechanisms should do, should deter governments or make governments think twice about, you know, or take more strenuous efforts to ensure that their house is in order, so that cases don't get, so that they are not, you know, they don't receive complaints against them before these international bodies. And I think we may see that with the optional protocol. In Spain, there is already a lot of discussion. Spain has ratified the optional protocol. Spain's domestic legal order with regard to ESC rights is pretty similar to Ireland's, in that they're constitutionally enshrined only as guiding principles, ESC rights, but not as fully justiciable. And for a number of other reasons, taking cases through the Spanish courts is extremely difficult. And it's for that very reason that lawyers, litigators, and NGOs are already strategizing about how Spain may actually be a very fruitful, fertile ground for trying to bring a test case, and certainly in the context of the issues that we've been describing today. So there are, I shouldn't be giving secrets away, but there are conversations, let's say, about what pathways might be followed. We are, however, also concerned, and I think Iain mentioned this in the working group, I mean, there is a big question as to how prepared the committee will be to adjudicate on, let's say, some of the more difficult kind of structural issues that we've been discussing in the course of today. You know, the committee may choose to begin with rather more straightforward cases that don't involve as in-depth and complex policy analysis as you know, determining whether a country's fiscal policy is in breach of its human rights obligations. But nevertheless, our hope, and I think the hope of many other NGOs, is that eventually the optional protocol will serve as a place where these kinds of complaints can be heard.
Thank you. And Aoife, you wanted to come in there.
Sorry, I just wanted to very quickly, and forgive me because I wasn't in the international mechanisms panel, but another mechanism that we should be aware of, and that perhaps should be, I know the Children's Rights Alliance will be doing work around this, and the Children's Ombudsman, pardon, sorry, the Office of the Children's Ombudsperson will be doing work around, is the issue of the optional protocol to the CRC that also makes provision for an individual complaints mechanism that can go to either children's civil and political rights or economic and social rights. And one of the reasons that it would be very attractive for that mechanism to be ratified is that we're very aware that when you have a human rights violation, you don't tend to find economic and social rights violations in isolation, or civil and political rights violations. So one thing that's very important about that mechanism is it will allow a UN treaty monitoring body to consider those rights violations together, which will be helpful in and of itself. And I suppose one of the things that we should note, however, though, in, I suppose, a voice of caution, is that even with the optional protocol to the CRC, we will have to think as advocates very strategically about how to get the committee to deal with children's economic and social rights, because one of the challenges with regards to the Committee on the Rights of the Child's work is that they haven't really engaged with economic and social rights very effectively. They've tended to piggyback on the back of the work of the Committee on Economic, Social and Cultural Rights without any consideration of how children might affect economic and social rights protections. And the fear is, will in fact, if we use the optional protocol, are we just going to get, you know, perhaps at best a repetition of what the Committee on Economic, Social and Cultural Rights is doing with a kind of lip service to children, or at worst are we going to see the Committee on the Rights of the Child make decisions about civil and political rights but not economic and social rights, because those are the rights that they're more comfortable with and they can choose to find a violation there while ignoring the broader economic and social rights issue. So sorry, that's just kind of other issues too.
Corey, did you want to come in there as well, and then we'll take another question?
Yeah, just to move on a little bit from that, and maybe to answer a question that was asked a bit earlier, is there hope? Is there any confidence in the future? And I know we've discussed here in great detail, you know, the things that haven't happened, but I actually feel there is hope, because we have reached a moment in the history of the world where we have a common language of human rights, which we didn't have before. We also have a common understanding of how we can realize our economic, social and cultural rights. We can identify the resources we need. We can actually measure them. We can actually say how we want them spent. And that's a remarkable development. We also are aware that 80% of the wealth of the world is controlled by a small group of people, and that even a 1% tax on that would probably satisfy all of the economic, social and cultural rights that we're discussing here. So what I'd say is we might be also well advised to look at our allies, as Ignacio has mentioned this morning from Spain, who are thinking along the same lines but maybe not using the same language. So I would say yes, there is hope.
Thank you.
I don't think it's a hard question, but from an NGO perspective, I'd like some suggestions. And it relates to a point Ignacio made this morning, and I thought it was extremely interesting, where he said that in relation to international bodies and looking at human rights proofing and equality proofing austerity measures, that since late 2009, that international bodies haven't been quite so interested, despite the fact that vulnerable groups are really only feeling the most drastic effects of austerity now. And I mean, I work in the Irish Traveller Movement, and if I talk about the traveller accommodation budget, in the year 2009 was 70 million per annum. This year it's 5.5 million, and next year the traveller accommodation budget on capital spending is going to be nil. So the real effects of austerity are being felt now, and it's really very serious. And also, I go to a little bit of a rant, in terms of the education budget in 2010, there was €7 million per annum provided for traveller-specific resources, and that was cut overnight. Not a policy decision, but a budgetary decision. And the effects of that are devastating. So what I would ask the panel is, and I know there have been some suggestions made already, but us as an NGO, and indeed other NGOs in the room, what practical suggestions can you make in terms of lobbying those international bodies, and indeed other bodies, to look at the effects of austerity and to equality and human rights proof budgetary cuts already made and those that are looming in the budget next month?
And then there was one last question, I think, just on this table over here, and then we'll begin to try to wrap things up.
This is more of a statement than a question, and I was wondering if maybe the panelists had any views on this. It appears to me that when we talk about ESC rights, we often forget about the C. So I wonder if the panelists have any views to offer on cultural rights, since there hasn't been a lot of discussion on that today. So.
Right, with 8 minutes to go, we open up a new horizon. Thank you. So, well done. So who'd like to respond from the panel? First question, second question, whatever you think.
I'll very quickly say that with regards to the cuts to the traveller programmes, I would go straight to the European Committee of Social Rights. I think it's a very strong decision case, especially based on how the decisions were made and the fact that they're focused on vulnerable groups. And I think there's a number of recent decisions and decisions that are coming through from that body that will be useful for you in terms of constructing a complaint. But there's a huge issue around implementation of the committee's decisions, so that's something you'll have to consider in your kind of advocacy and your strategising as well.
I mean, I think it's obviously very important to look at the range of different individuals and bodies. So, for example, the Commission on Human Rights and the Council of Europe has already been mentioned. He, as did his predecessor Thomas Hammerberg, continues to focus on the Roma. As I said before, the irony is there is a huge amount of focus on Council of European institutions and EU institutions, but the fact is that it often doesn't translate into the change. So I mean, I think it's a question of the long-term work that can be done in terms of using the legal mechanisms, such as the social charter body, but also trying to get, maybe the commissioner lobbying for, maybe to do a visit or to issue some kind of statement as well. And then I think also, which I think is another important thing, is looking at the EU and possible infringement proceedings under the Race Directive. And I can tell you that there's an increased willingness within the European Commission, without going further, to at least consider potential infringement proceedings for failure to implement the Race Directive, as opposed to the traditional way of looking, which is failure to transpose into domestic law. And we saw attempts to do it with France and the Free Movement Directive, and that failed. But I think that what I'm going to say is that the prospects are looking good for Amnesty, and other people have been working on this with our partners in the Voting Rights Centre. And I think there's an increasing, certainly within the Commission, if not up to the political body, the College of Commissioners, to potentially look at infringement proceedings. And I think once they find one country in breach, then I think you will see a potential domino effect, because other countries will also be in breach.
Nolan?
Just on the international mechanism to use to make that link between policies, austerity policies, and the effect on the people. I think the UPIs presents the advantage of having a political side to it, and having states from all over the world being able to raise it. So it's not an EU discussion where they're all going to be facing the same decisions. But if you bring in countries from Latin America, from maybe Asia, that could say to European countries, well, while you apply those cuts, please take into account the minorities, the vulnerable people, as they sometimes call them, and especially that those countries could be interested in those issues, because some of the minorities and vulnerable people are coming from Latin America, Africa, and Asia, so they could have an interest in that. And it was mentioned this morning that the Human Rights Council had two special sessions on crisis and the effect of crisis. It was, I think, led by Cuba, so it's for human rights defenders. It's a bit difficult sometimes to approach Cuba in a proactive way on human rights, but there's a possibility, I think, at the UPR to approach this question, which is not, I mean, probably treaty bodies experts would not feel very compelled to talk about a more, not such a legal way, but just having a reflection, like getting governments to have a reflection on how they are cutting budgets and the effect it has on people.
Thanks, Roland. I know Ignacio and Mary also wanted to come in, but you might also just think about if we can at least begin to respond to the final point on cultural rights and where they fit as well. But Ignacio, you were going to come in there for a moment, I think, were you? And then Mary.
Okay, actually it was on the first question. Just to clarify, when I said that interest of international bodies waned after 2009, what I was referring to there was specifically international political bodies, political governance forums such as the G20, the political bodies within the UN system. I mean, even the Human Rights Council is really more a political forum than an expert human rights mechanism. I was referring to those bodies, and there was you could see a flurry of activity from 2008 to end of 2009, where there seemed to be, we really did seem to be on the verge of a shift in the way global governance institutions were, recognizing at least the big structural flaws in our global economic order and committing to address them. That moment passed very, very swiftly, and states went back to their narrow domestic parochial self-interest and quickly forgot the collective good. I was referring to those bodies because conversely the international human rights mechanisms, I think, have taken this time to warm up. And I think now we're seeing some interesting opportunities and stronger potential for bringing cases related to austerity through those mechanisms. So I would make a distinction between those political forums and the human rights ones. One thing that I think might help, though, in terms of galvanizing more political interest at the global level, is actually the current discussions underway on the post-2015 development agenda. As many of you know, there's a big discussion underway on what should replace the Millennium Development Goals, the MDGs. And one thing that's interesting in that debate is that human rights is actually making a much stronger headway than any of us anticipated in terms of, the new framework that gets decided by 2015 may just make more solid reference to human rights than its predecessor. And one issue that many of us are trying to get on that agenda is that poverty is not just an issue of the South. The MDGs were this very flawed framework, apart from the fact that they were not human rights friendly. They were seen as a pact between northern countries and southern countries. And we and many others are confident that the new framework may well address issues of poverty and inequality in industrialized countries, in emerging economies. And the relevance to this is that what has changed in the mindset is the global economic crisis and the fact that countries such as ours are going through levels of deprivation not seen in many decades. So I think that might be a forum that might stand a chance of notching up the importance of these issues in global political forums.
Thank you, Mary. And Roz is looking at me about the time.
I'm going to cheat and try and bring in cultural rights, but only in the most meaningless way, I think. No, I wanted to address what I thought I heard, and I might have misheard your question, but I thought was part of your question around the role of equality proofing and as mechanisms to protect against cuts. Yeah. I suppose to broaden that to poverty proofing, equality proofing, gender mainstreaming, these are all sort of mechanisms and tools that people have developed to try and strengthen the capacity to make good policy and to make sure that budgets are protected around rights. And I suppose if you take the definition of poverty that does include social participation and cultural participation and try and widen the use of those tools, there is quite an effective campaign at the moment, but equality proofing of this budget back on a serious political agenda. And I think one thing is interesting, taking up something Aoife said earlier, is I think there's a lot of senior civil servants and indeed party politicians in government who are realising that they need the tool of equality proofing to equip them as much as possible prior to budget day to get arguments against some of the decisions that are going to be made. So you can actually see that you're getting strange allies in some places around the need to have these proofing mechanisms used effectively. I think what they do as well is they bring in that thing about the right to participation in a meaningful way, because true proofing would actually engage with people about the impact of the cuts on their lives, and also it's information that comes out the other side that can be used to mobilise people. So I actually think it is a very powerful tool to bring alive some of the instruments that we have, and hopefully that it might advance a bit in this budget.
Thanks very much, Mary. We're going to wrap it up if that's okay. We honestly, I don't think we're going to have time. One more? Okay, so one last question from here then.
Irene Alger from the Autism Rights and Equality Alliance, but literally there's one point that I just literally wanted to summarise relating to disability as a global issue, and it very much just ties into your comments in terms of the post-2015 campaign. Obviously from the point of view of Ireland, we have such a strong record in terms of Irish aid and the humanitarian work we do abroad and so on, and from the point of view of the white paper review on Irish aid, there was the task force from a disability perspective, and I very much welcome the fact that in the Oireachtas in April this year, disability was put down as a priority issue on the agenda. From an Irish perspective, the difficulty arises out of the non-ratification. Having said that, obviously Ireland have a strong voice to play in terms of the Human Rights Council and so on. So in terms of just a conclusion from a disability perspective, I'd like to just give a statement from the task force from Irish Aid in terms of 3 items. that the adoption of disability as a cross-cutting issue in relation to post-2015, the implementation of a twin-track approach, and number 3, ensuring that mainstream development activity and humanitarian assistance do not create intentional or unintentional barriers to equality of participation by people with disabilities. The reference to those 3 points are in the task force in terms of disability and the white paper review.
Okay.
So thank you for letting me finish on that.
Thanks very much. And we are going to close it up here, if that's okay. Well, what a day. First of all, thank you all very, very much indeed for coming. I suppose just to try to reflect on back on some of the aspects, I'm standing here thinking to myself, well, we're living in an Ireland right now where every single political party in the Oireachtas and every political grouping in the Oireachtas has in the last year said that we need to explore the idea of enshrining ESC rights in our constitution. Every single one without exception. Both government parties at the moment put forward a bill in 1999 to enshrine those rights in the constitution, and 14 members of the current government supported and voted for that bill, including the Taoiseach and Taoiseach. Every party in opposition and all the political groupings in opposition support the idea that these issues need to be considered as part of the Constitutional Convention, and that we need to have this conversation, this real dialogue about how we better provide for these essential rights and whether or not we need to enshrine them at the constitutional level. But that's not yet broken through into a meaningful process that seems dedicated to doing just that. I have to say I'm really heartened both by the fact that all of our speakers came here today. And, you know, very often when you're organising a conference like this, you have a wish list of people that you'd like to get to come along. And I remember, because this has been planning, Ros and Louise and everybody's been planning this for a long time, you hope that you might get 40% of them. I have to say we were delighted that we got everybody that we really wanted to get. And I think the quality of our speakers today and the quality of our panellists has been quite extraordinary. We've been very lucky indeed. And I think that speaks to the desire for this work to happen, the absolute desire right across not just our society here in Ireland, but right across the human rights community, the social justice community generally, and beyond, to begin to find ways to answer these very, very difficult questions. You know, equally, we were very pleased indeed today to have people from the civil service here with us today as well. And I have to say that we have seen over the last 2 years in particular an increased engagement at the civil service level and indeed to different degrees at the political level in trying to explore how we can begin to consider the rights framework as a meaningful way of addressing some of these very complex and difficult issues. We have an enormously long way to go, but you know, we're back to that question about hope. There's always hope, but I think now there's more than that. There's will and there's determination. So yes, we have to mobilise, but the other thing that we have to do as well is we have to prevent credible solutions, because the thing that we haven't done thus far, and I think many of the panellists said that so clearly at various points, we have to be able to convince politicians, policymakers, and civil servants, and indeed the wider public, that the rights framework matters, not because it's a worthy thing to do, not because it's something that a certain class or section of society seems obsessed with, but because it can have real impact, because it can make a real difference, because it can make a significant contribution, but only a contribution, to answering very, very difficult questions indeed. Human rights law doesn't provide either simple nor indeed all of the answers to the challenges that Ireland faces, or indeed that any country facing austerity or economic crisis faces. But they do play a role. It's critical that the legal, economic, academic, media and political debates about Ireland's current predicament and future prospects are informed by the human rights obligations to which Ireland is bound. And that's one of the key things that we need to articulate more clearly. No government can be above the law. No state can be above the law, and states wrote this law. We must never lose sight of the need to point out the hypocritical situation of a state going out into the international community, be it Ireland or any other state, and advocating and agreeing significant treaties and then signing up and ratifying them, accepting legal obligations, and then utterly and completely ignoring them as if they have no merit or value back here in our own country. We have to get serious about reminding our government that the law applies to them as well. Mobilisation matters, solutions matter, discussion matters, and let's not waste a really terrible crisis, and it is an appalling crisis that we face. It'll be we'll look back on it with an awful lot more horror if we don't emerge from it in a better position as a society, as a sector, to really advance these issues and to build a fair and more equal society. Our own government committed just over a year ago, 22 months ago now, in the programme for government, and I'll quote, that by the end of its term in government, Ireland will be recognised as a modern, fair, socially inclusive and equal society. Well, we absolutely believe that addressing the protection of economic, social and cultural rights, particularly in the context of the economic crisis, is a vital step in moving Ireland closer to that ambition. And we believe if that doesn't happen, there is absolutely no way that the government can deliver on that bold and radical aspiration. I mean, the programme for government, we spoke a little while ago, I remember in one of the sessions this morning, there was a suggestion made that there was a democratic mandate for austerity. I haven't seen anything that suggests there's been a democratic mandate given to this government or indeed any other government for austerity. You know, the fiscal compact was a mandate for budgetary responsibility. It was a mandate for, it seems to me at least, at the very most, good financial management. It didn't say that the way to balance your books was austerity. It said you must balance your books. The programme for government, if we take it as the mandate that this government agreed, having been elected as a coalition government, sets out those kinds of principles. It talks about a democratic revolution. It talks about a bold and radical future. It talks about a fair, socially inclusive and equal society. And it says that all state bodies must have due regard, pay due regard to human rights and equality. That's the democratic mandate that this government has. And we have to hold them to that. But we also, frankly, have to get an awful lot more serious and an awful lot clearer in presenting solutions that help them to deliver that as well. Hopefully today was an important moment in that process. We've been really encouraged by the fact that, as I said, we got such fantastic speakers, but such a wonderfully engaged audience as well. You really helped to make the day something very special indeed, and I know we'll be reflecting on it for some time to come in Amnesty International here in Ireland. So thanks very much indeed. Big hand to our panellists and safe home.